I've covered hundreds of congressional hearings, but what I witnessed today should terrify every American who believes in constitutional government. I watched a Texas congressman discover, for the first time 3 weeks ago, that his own phone records had been secretly seized by the Department of Justice, not because he committed a crime, but because he supported Donald Trump. The moment he held up that email, revealing how his private communications were handed over without his knowledge, you could feel the constitutional crisis crystallizing in real time. This wasn't just about Jack Smith anymore. This was about a justice system that had been weaponized against American citizens for their political beliefs. 400 conservative groups, leaders across the country, phone records, financial records, private communications, all swept up in what the congressman called the most egregious abuse of power he'd ever seen. But here's what made my blood run cold. Smith's responses weren't denials. They were careful legal dodges from a prosecutor who knew exactly what he'd done. When pressed about limits to his investigation, about targeting citizens for being conservative, about continuing to prosecute even after a federal judge ruled his appointment unconstitutional, Smith's answers revealed a justice system operating without boundaries, without accountability, and without respect for the very Constitution he swore to defend.
Thank you very much. Thank you very
recognize
much.
the gentleman from Texas.
Thank the Chairman. Mr. Smith, how many members of Congress or the Senate did you subpoena phone toll records?
As I sit here right now, I do not recall a specific number.
Is this the complete list right here? Let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. Thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I had been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that establish and open the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco. And you briefed the AG and deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, as we already talked about, my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and frankly anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we
So
stated...
why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election context was filed and after the presidential electors were certified? What about Jenna Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking...
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. I yield back.
Gentleman yields back.
Did the gentleman have the opportunity to respond?
If the gentleman wants to respond, he can.
With respect to the last point, Judge Cannon's order specifically limited her finding to that proceeding. So there would be nothing improper about continuing to litigate the cases in Washington, D.C. And with respect to Florida, there was nothing improper about taking an appeal of that very decision.
What I witnessed in that hearing room wasn't just political theater. It was the systematic breakdown of constitutional governance playing out in real time. I've watched Jack Smith testify before, always measured, always careful with his words. But today felt different. When that Texas congressman held up the email proving his phone records had been secretly seized 4 years ago, something fundamental shifted in the room. The numbers alone should alarm every American. Over 400 Republican groups and conservative leaders had their private communications and financial records swept up in this dragnet operation. This wasn't targeted law enforcement. This was political surveillance dressed up as prosecution. I saw Smith's face when pressed about limits to his investigation. The careful pauses, the lawyer speak, the refusal to give straight answers about whether there were any boundaries at all to his power. Here's what makes this constitutional crisis so insidious. The separation of powers violations happened in plain sight, with congressional phone records seized without notification, making oversight impossible. You can't check power you don't know is being exercised against you. The congressman couldn't object because he didn't know his records had been taken until 3 weeks ago. That's not accidental. That's systematic circumvention of constitutional protections. But the most chilling moment came when Smith was confronted about continuing to prosecute cases even after a federal judge ruled his appointment unconstitutional. His response wasn't remorse or acknowledgement. It was defiance, arguing he had the right to continue because the ruling was limited to one proceeding. I watched a prosecutor claim the authority to decide which constitutional rulings apply to him and which don't. What we're seeing isn't just prosecutorial overreach. It's the transformation of the justice system into a political weapon. When prosecutors can target citizens for their beliefs, seize private communications without notification, and continue operating after being ruled unconstitutional, we're no longer talking about law enforcement. We're talking about authoritarian power exercised through legal institutions. The congressman's question about Cleta Mitchell crystallized everything wrong with this investigation. Filing election contests, challenging vote counts through legal channels, is fundamental democratic participation. Yet Smith's office monitored her communications 2.5 years after the election was certified. Since when is exercising legal rights grounds for criminal surveillance? This hearing exposed something darker than individual prosecutorial misconduct. It revealed a system where constitutional constraints have been abandoned, where political opposition justifies unlimited surveillance, and where prosecutors operate as if accountability is optional. The real scandal isn't what Jack Smith did, it's that he believes he had the right to do it.